the rights and liabilities of the mortgager from section 60 to 66. Rights and liabilities of mortgagee, section 67 to 77. Under this topic, we have understood section 67, right to foreclosure or sale, and then we have moved to section 68, right to sue for mortgage money, and then we have understood section 69, when the power to sell the property without the help of the court or without coming to the court, we have understood. Okay. So now we will move ahead. We will try to understand section 70. Section 70, accession to mortgaged property. While I was explaining about the rights and liabilities of the mortgager, I have given you section 63. The same section, the same details you can bring here and you can understand. You can write the same thing. There is nothing more to understand this one. So, Milind, can you repeat what I have taught you in section 63? Accession to mortgaged property.
Yes, sir.
Can you explain for 10 minutes? If you have notes with you.
Sir, I have notes, sir, but for section 63, I think I have missed the class, sir. Yes, sir.
Can you don't have any notes at all? You don't remember anything?
Sir, I remember little bit only, not very much, sir, like in kinds of accession also. In natural accession we have seen the
now you read now you see Milan,
yes,
simply
yes,
you read the screen, you will.
Yes, sir. If after the date of a mortgage any accession is made to the mortgage property, the mortgagee, in the absence of a contract to the contrary, shall for the purposes of the security be entitled to such accession. Yes.
What is accession? Levin?
Sir, having access in a premises, like you can enter that premises, if I'm not wrong.
Mansi?
Oh, sorry, sir. I would like to alter my answer. Basically, in this term, in this context, it means like the addition of a land. Like we discussed about a situation of a newly formed island, which all of a sudden appeared near the Bay of Bengal. So the here accession refers to that concept.
Yeah, very good, very good. Okay, so section 63 I have explained you these things as. Now we have to repeat once again. Okay, what is accession? Enhancement, addition of land to the existing mortgaged property. Okay, very simple. So, addition of new land or formation of new land to the existing mortgaged property. Now, how many kinds are there? There are two kinds. One is the natural accession, where the natural forces, Mother Nature, they help in the formation of new land. So the formation of new land is called accession, natural accession. And in the natural manner, there will be the destruction of the existing land. That is called diluvian. Okay? Mother Nature, they create the land and also they will destroy that land. So destruction of land by Mother Nature is called diluvian. So the opposite word to this accession. So kinds of accession: number one, natural accession, and number two, acquired accession. Acquired accession, that day I have told you that when the land is there, and maybe the government may give additional land, maybe some 10 meters or 20 meters, and the government may tell you, please grow tree here. Okay, so anything that has been given by the government to the existing immovable property, existing mortgaged property, yes, it is called as acquired accession. Okay, so these two accessions, when any addition of land has been made, the mortgagee is having the right to use and enjoy this property up to the complete period of the mortgage. So, until that time, the mortgager should not disturb him. He must allow the mortgagee to use the newly added land as well, along with the mortgaged property. When the time is over, when the mortgage period comes to an end, then the mortgagee has to give back the complete possession of the property to the mortgager. Okay, so this much what all I have explained you in section 63. So you simply explain once again here under section 70.
So
Okay.
I just have a doubt.
So
When hello, yeah, can you hear me, sir?
yes ma, please.
Yeah. Sir, when this
Yes,
thing
please.
you have already covered in section 63, then why is it the need to again the same concept to be dealt under section 70? Like, what is the slight difference between both? Because it is very similar to each
Both are
other.
same.
So
Both are same. It is both are same. Okay. So here once again, the makers of the law, they have created this section. Okay, specifying once again that this is the rights and liabilities of the mortgagee. Okay. I don't know the mind of those makers, right?
because it is
But both are
exactly
same.
sir. Yeah.
Same.
So in case any question comes relating to accession, so we can write only one section, or we have to write both the sections?
See, accession, the right, that is accession of the mortgaged property in respect of the mortgagee. If they ask you, specifically if they ask you mortgagee, you write section 70.
Mortgagee.
Or if they, for example, if they simply say accession, short notes, then there you have to explain. Section 63 explains the accession right to the mortgager, and section 70 explains the accession right to the mortgagee, so that you will get additional marks for this. Majority, they may not answer. Okay, so if you remember these two sections, one for the mortgager, one for the mortgagee, but the contents are same, you will get additional marks for that. Okay. Yes, ma'am. Now we will go to section 71, not important for your examination. Okay. Now 72, rights of mortgagee in possession. When the mortgaged property is in the custody, in the possession of the mortgagee for the specified period, then both the mortgager and the mortgagee may not have entered into any special terms and conditions. Consider that they have not at all mentioned any terms and conditions. Then the law says, yes, the mortgagee who is having the possession of the property in the absence of any special terms and conditions in the deed, such a mortgagee is having the following rights. What are those rights? Okay, the first one. I told you, I have explained you Section 63A. While I was explaining about the rights and liabilities of the mortgager, there I have explained you Section 63A. It speaks about improvements to the mortgaged property. Hope you remember.
Yes, sir.
Okay, yes. Now, for this point, for this section 72, the first point is the repetition of the same section 63A once again. So what is this? As you have already known, let me explain once again. When the property is in the possession of the mortgagee and the mortgagee is having the duty, he is having the duty to take care of that property, and while taking care of that property, he has the right to spend the necessary money in the process. That means he must protect the property so that the property shall remain a valuable security. The property should not become an insufficient security. The mortgagee may be ordered by a governmental authority to take certain actions or certain steps regard to the property. Then the mortgagee has to bring the matter to the knowledge of the mortgager. He must inform. In whatever mode it is possible, the mortgagee must inform to the mortgager about the necessity to protect the property. Then, some of the mortgager who are financially sound, they may listen to the mortgagee and they themselves will spend the money and do the necessary work in order to protect their own property. But there are mortgagers who are having the pain, who are not having the power of money. They cannot take immediate action to protect that property, to spend the money in the rectification or repair or doing something to the property. Then the mortgager can tell the mortgagee, you please carry the needed things, the necessary action and you spend the money from your pocket and keep the account, and I'm going to reimburse the amount of money. So, when such a situation takes place, the mortgagee will secure the right to spend the money for the protection of that property. Remember very carefully here. When such a situation arises, the mortgagee must bring the matter to the knowledge of the mortgager. Mortgagee cannot spend the money on his own without bringing the matter to the knowledge of the mortgager. He must inform the mortgager, and when the mortgager gives the permission or requests the mortgagee to spend the money, only then the mortgager will have the right to spend the money and to protect the property and to keep all the accounts in such a manner so that the mortgager is going to reimburse the money. Now you can ask me a small question. Consider the mortgager is not available easily. Consider the mortgager is not available easily. He may be away in a foreign country, or he may be very, very busy personality. He cannot be communicated. Then the act of necessity has to be done within the short period of time. Can the mortgagee spend the money to protect that property? See, when such a situation comes, the mortgagee must show that he tried to communicate to the mortgager and he could not communicate, and the act was very much urgent. Immediate attention was needed to the property. So he can spend the money to protect the property, and the property will be a valuable security. It will have its value. There will not be any reduction in its value. So the law says, yes, the mortgagee will get the right to spend the money for the protection of the property. So I'll just recollect one illustration to you. Mr. A mortgaged a house property to B for a period of 10 years for 10 lakh rupees. And during the third year of the mortgage, the municipal authority gave a notice to the mortgagee to reconstruct the weak compound wall of the house, which may fall on the pedestrians. B received the notice and gave the information to the mortgager, but failed to take any action. Then B has decided to demolish the wall, and he reconstructed the wall. He spent rupees 1 lakh for the same. Now this amount is a lawful spending by the mortgagee. This amount has to be cleared by the mortgager with 9% of simple interest. You know, here what I want to explain is the mortgagee has given the information to the mortgager, but the mortgager has not given any consent, or he has not rejected or accepted. He just kept quiet without taking any action. But the municipal authorities has given the notice to the mortgagee. See, this week, compound wall may fall on the pedestrians and they should not suffer any injury. So better, we will give you 15 days of time. You just reconstruct the wall. So now, the mortgager has not at all responded. He kept quiet. Then the question, can the mortgagee spend the money on his own and two, keep all the accounts, and then can he claim the money from the mortgager? Yes. Yes, the mortgagee is having the right to get back the money from the mortgager, at least after the expiry of the mortgage period, with a simple interest of 9%, and the mortgager has the duty to reimburse. Okay, so this simple illustration you can write for the first point. Then go to the second point. Right to spend the money for supporting the mortgage's title to the property. You know, there are land sharks, land grabbers, land mafia everywhere in our country. They're always looking for the grabbing of the property, immovable property, by hook or by crook. So, when the property has been given to the mortgagee, the mortgagee is enjoying the property, he is having the possession of the property, then the mortgagee must be always careful. He must keep his eyes and ears open so that the property should not suffer. There are people who are trying to take away the property, and they may file bogus cases or false cases on the property which is in the control of the mortgagee. When any such information received by the mortgagee, then the mortgagee should not keep quiet. Mortgagee must speak to the owner, that is the mortgager. He must bring the matter to the knowledge of the mortgager, saying, "Sir, I heard this kind of rumors. There are people who are trying to file false cases, or they have filed false cases of ownership against the property. I have received the notice. So you please take action." He has to tell the matter to the knowledge of the mortgager. Definitely, the mortgager, because he is the absolute owner, he will not at all keep quiet. He will definitely take action. The mortgager will appoint the good advocate. He will pay the fees to the advocate. He will provide all the evidences to the advocate. And he will fight in the court of law to protect his property. This is not an easy matter. It's not an easy subject. going to the court, appointing a very good lawyer. I'm using the word very good lawyer. Majority of the lawyers do not know the law. My professors used to say, majority of the lawyers do not know the law. So, finding a person, a man of knowledge, is very, very tough. The lawyers may destroy, the ignorant lawyers may destroy the case. So, finding a very good lawyer and to meet his expenses and to pay the fees is not an easy job. So, the mortgager will generally take care of their property, but bad luck sometimes. The mortgager may not be in a position, his financial condition is bad, he cannot afford to go to the court, then the mortgager can tell to the mortgagee, Mr. Mortgagee, you are having the possession of my property for this much of period. Yes, you please, I will give all the documents. Okay, you please find a very good advocate, file the case and go to the court, attend all the proceedings, and then keep all the accounts, and I'm going to give you the entire amount of money. I'm going to reimburse you all the expenses. So, when the mortgager fails to take care, when the mortgager fails to spend the money in protecting the property in the court of law, or when the mortgager is not having the ability to protect the money, property, then it will give a right to the mortgagee to spend the money in the court of law and to protect the property and to protect the ownership of the mortgager. So, this is the caution that is required on the part of the mortgagee. Okay, so I'm just giving a small illustration here. A has mortgaged agricultural land to Mr. B for 25 years. So A is the owner of an agricultural land. He has mortgaged the land to Mr. B for 25 years. Consider the mortgage is in the 5th year. 25 years total period. When the mortgage is in the 5th year, mortgagee received an advocate's notice. Some advocate has given the notice to the mortgagee. Then immediately Mr. B informed the same to the mortgager. But the mortgager told Mr. B, please take necessary steps. I can't take any action now. You are the mortgagee, Mr. B. Come on, you take an action. Immediately, Mr. B found a very good advocate and filed the case for protecting the property and the ownership of the property. So Mr. B, the mortgagee, spent about ₹1 lakh towards the sale. This is the lawful spending in guarding the property. This amount of money shall be reimbursed by the mortgager. Okay, so this is the another point. Now we will go to the next point. For making his own title good against the mortgager. So far we have understood when some third person are trying to harm the property and the matter comes to the knowledge of the mortgagee, the mortgagee will bring the matter to the knowledge of the mortgager, and the mortgager may take action or the mortgagee may take action. But here, this point, it is very slightly different. For making his own title good against the mortgager. You know, in our country, there are good people, honest people, and also there are opposite people, the bad people, the troublemakers. Sometimes the mortgagers may become the enemy of mortgagees. Sometimes the mortgagers may become the enemy of mortgagees. You know, we have weapons in our country, weapons of destruction. Religion, race, language, place of birth, as we have studied in the Constitution. I'd like to take one small illustration. Bangalore city, a population of 1.5 crore, and the people from different parts of the world are living in Bangalore city. There are owners of houses, flats, buildings. Some of them may belong to one particular language, one particular religion, one particular, so many dirty things. Consider one land owner or one flat owner or one house owner wants to mortgage his property to another person. Consider, for many days he could not get any good persons at all. But one day, an engineering student came, says, I will be here for the next 4 years. I want to mortgage. I want to take possession of your property. And the owner was very happy. He said, don't worry, I'll give you, and this is the price, the mortgage money. And that boy belongs to one part of India, and the owner of that property belonged to the local population. And that boy belongs to a different language, different religion. He do not have any supporting people here in Bangalore city. Then the local, that owner, you know, he gave the money, he gave the possession of the property to that boy, to that engineering student. And gradually, after 1 year, the owner starts making one or the other quarrel with that boy, with that student. So this engineering student, who is from different religion, different language, different caste, different community, he wants to concentrate in his study, but now there is a disturbance. And the owner has told, the mortgager has told, you please get out of my property. Do you know some of the owners will use all fraudulent means to kick away the mortgagee from the property. So, in such a circumstance, this provision comes into help. So, this provision says, the mortgagee has given a good amount of money to the mortgager for which he has received the possession of the property. I repeat, the mortgagee has paid good amount of money to the mortgager. For that reason, the mortgagee has received the possession of the property. When the mortgager creates problems, then the mortgagee should not keep quiet. He has the right to protect himself. He has the right to protect his interest in the property. So, whatever lawfully possible, he must take action against the mortgager. What kind of action the mortgagee can take against the mortgager when there is a disturbance? See, especially the local population, they always wants to cause harm to the person who is from a different region, different language. So that mortgagee, there is a man, there was a doctor, he used to tell one sentence. I always remember this sentence. God helps those who help themselves. An old doctor has given me this sentence. I repeat, God helps those who help themselves. First we must have courage. The mortgagee must have courage. He cannot simply walk away from the property because of the disturbances that is created by the mortgager. Whenever there is an unwanted interference, unwanted quarrel by the mortgager, the mortgagee, he can take the help of some known persons in the area. He can try to advise that owner of that property not to interfere, not to create disturbances to the mortgagee. And if the mortgagee continues, if the mortgager continues to harm, continues to interfere, continues to quarrel, then the mortgagee has the right to find an advocate, a good advocate, an advocate with of knowledge, and he must take suitable, necessary direction from the court of law against the mortgager. You have studied so many laws by this time. Tell me, under which law the mortgagee can take the help of the court? What kind of help the court is going to give him? Yeah, all of you, come on, say one by one, what kind of direction the court may give. Come on.
Sir, as per under section 67 provision, a mortgagee can seek help from court to get his money back. If I'm not wrong.
Very good. Very good.
Right to foreclosure or sale, 67.
Okay, okay, good, good. Then, see, I told you, you are a student. You have to stay there for 4 years. In the first year itself, the owner, that is that mortgager, is causing disturbances, quarrels, interferences, unwanted visits, so many things. Now you have to stay for the next 3 more years. You feel that I have to concentrate in my studies. I can't go here and there searching for houses, etc. Then you have studied one small beautiful law. If you in your first year of LLB, okay, you might have studied this. I don't know. You should tell me. Specific Relief Act. Have you studied? Have you heard this law?
Yes, sir.
Okay. Along which subject you have studied this law?
Contract.
Contract 1 or 2?
Contract 1.
Very good.
Contract 2.
Okay. So generally it is with contract 1. Okay. From
2
section
has
1.
MD Act if I'm not wrong, sir.
Okay. Okay. In some universities, yes, maybe. Okay. So Specific Relief Act, wonderful law. And there, when such things happens, when there is an unwanted disturbances from the owner of that property, from the mortgager takes place, there are so many remedies available under the Specific Relief Act. One such remedy, I think you know this. Injunctions.
Yes.
Yes, sir.
What is injunction?
It is of 2 types, that is permanent and temporary. So when an injunction order is passed at that particular time, no one should interfere on that particular land. So like the particular use of that particular land goes on a restriction. Stop, like no party can use or make profit out of that particular land.
Very good, very good. That's good. Now the question here. Consider this engineering student got a very good lawyer. He said, don't worry, I will teach lesson to that man. So, that lawyer gave a notice to the mortgager saying, you should not interfere with the lawful possession of my client. If you interfere once again, then I am going to commence the case against you and you have to pay compensation for that. So, some of the mortgager, when the moment they receive the advocate's notice, they may keep quiet. They may not continue to create any problems. But there are born troublemongers. They will not keep quiet. And then the advocate has to file the case in the court of law and call upon that mortgager to the court. You know, when the mortgager is compelled to appear before the court of law many times, and when he is made to sit in the court from morning 10:30 to afternoon 2 or 3 o'clock, and he will know the taste of the practice of law, the pain of waiting in the court of law, then the advocate may secure an injunction against the mortgager, saying the court will give the direction until the completion of the period of mortgage. You, the mortgager, you do not have the right to interfere. So, for securing this order of the court, I think that student has to spend money. It is not free. It is the law advocate services are not free. He has to spend the money. Now, whatever money that he has spent, the mortgagee, that student, has the right to demand that amount of money from the mortgager. So, the mortgagee can protect himself from the pain, from the harassment, from the interferences, from the trouble of the mortgager, and also he shall have the right to be reimbursed by the mortgager. Okay? So, this is very simple and you can easily remember this one. Now, another important section, that is section 73. Right to proceeds of revenue sale or right to compensation on acquisition. There are two matters that you have to know. Yeah, I'll ask any one of you to give answer to this. What is the meaning of revenue sale? What is the meaning of acquisition? Can anyone tell me?
Sir, paying of
What
periodical taxes to the government.
हाँ. उतना ही मिलन, आगे तो बढ़ो, बोलते जाओ.
And so if any in cases of default, then government will give notice to the owner.
हाँ, ठीक है. हाँ.
And sir, if the property is mortgaged to someone and the mortgager has failed to pay the taxes, and after the notices are given repeated to the mortgager by the government, then government can attach the property and declare the selling of the property by public auction, sir.
Oh yes. Very good. Good. Do you know the famous person in our country, in the field of sports, Steffi Graf? Do you know the sports person by name Steffi Graf?
No.
No? You have not heard of this person? Nobody. Steffi Graf.
I don't remember so much, but so like is she is a tennis player or something, sir?
Okay. Now, how many of you have the craze? Okay. Tell me. How many of you have the craze to watch sports? Which sports that you like?
Cricket.
Oh yes, cricket. You know, in England, in France, there is a tennis tournament, right? Mr. Federer, Mr. Andre Agassi, they were the champions of this game. You know, in London, so many people will go and watch this sports. There was a wonderful person called Steffi Graf. She was a wonderful player. Wimbledon, you know, Wimbledon tournament. This lady was the highest taxpayer, and these sports persons will have the assistants or secretaries. This lady, her father himself was the secretary, and every time they were maintaining the income and expenses, and accordingly they were paying the taxes to the government. Once it so happened, very unfortunate thing, her father, who himself is the manager for that sports lady, he failed to disclose certain income, so he failed to pay the tax to the government. If the same thing happens in our country, you know what it will be. But there, father was arrested by the authorities, and he was imprisoned for the non-payment of tax. And a very hefty amount of penalty was imposed on them. Tax is the paramount payment made to the government by the people for the proper administration, for the proper governmental action in the society. In our country, there are different taxes. There are defaulters. There are sincere taxpayers. I'm using the word, there are sincere taxpayers. There are defaulters, not for once, for many times. They continue to default in the payment of taxes to the government. Some of them are so thick-skinned, they do not worry, they do not want to pay the taxes to the government. So, when there is a failure to pay tax from the immovable property, the government gives notice to the owners of the property for the payment of the taxes. But when the owners of the property refuses to pay the tax to the government, then the final resort available to the government is go, seize the property, confiscate the property, and conduct the sale of that property openly, lawfully, tastefully, and collect that amount of money in satisfaction of the tax. Such a sale is called revenue sale. See, read it. When the land revenue from the property is not paid in time, there is a default. The government is having the power to sell off the property and to collect the tax from the proceeds. The government can conduct the sale and retain the money. This is called revenue sale. If the mortgaged property is sold by authorities, then the mortgagee can file the petition before the authorities and demand the mortgage money. Okay, let me take one small simple illustration. Mr. A is the absolute owner of the house property. Mr. A is the owner of the house property. He has not paid the tax to the municipality for many years. So he was very happy man, a stingy man. He wanted to save everything. So he has not paid the tax for many years. So this fellow, Mr. A, he received notices from the municipality. He never answered. He kept all in his home without informing to others. One day, an innocent man, Mr. B, comes to Mr. A, and Mr. A mortgaged the house to Mr. B for 5 years for 5 lakhs of rupees. Mr. B do not know anything about the default in the payment of taxes. He do not know. Mr. B is innocent. He paid 5 lakhs of rupees and he took the property. You know, bad luck sometimes. After 4 or 5 months of the commencement of the mortgage, suddenly the government authorities came, seized the property, removed this mortgagee from the possession, and the government gave advertisement in the newspapers, advertisement in the governmental television channels, saying that here is a property, this has been seized by the government and the owner has not paid the tax for so many years. So we are conducting the public auction on such and such a date and such a time. So the government has given the notice to the common public to participate in the purchase of that property. The government, according to the notice, they invited many people. They came, they took part. It was a free and fair public auction. There were terms and conditions. Consider one Mr. C, an unknown person, purchases the property because he is the highest bidder. He is the highest bidder and he purchased that property. The government secured a very big amount for the sale. Consider the government secured a very hefty amount of money by the selling of that property. Consider about 20% of that money was the tax, default of tax. Now these authorities, they deduct the tax that was due, the arrears of tax, and they further deduct all the expenses incurred in the conduct of the advertisement, in the conduct of public auction. All the expenses shall be deducted from that amount. After satisfying the tax and the expenses, still there is sufficient money with the governmental authorities. You know, in this process, the loser is the mortgagee. He do not know anything about the default by the mortgager. Now he has paid and suffered loss. He do not have any other alternative security. So, Mr. B, with all his documents, he has the right to approach the concerned authorities. He can make a request with the petition, with the document, the mortgage deed. He can make a petition to the authorities. He can request the authorities, "Sir, I am the lawful person who has paid the money to Mr. A. I do not know anything about the default. Now, Mr. A is not giving me the money. Now you have the residue amount. You have sufficient left amount with you. Kindly accept my petition, accept my request, and give me the money which is supposed to be mine." So if the money is sufficient, if it can satisfy the mortgage money, then that authority, they will call upon Mr. A, the owner of that property, and they will conduct an inquiry with proper notices, and afterwards the government is going to give that amount of money to the mortgagee, because he should not suffer. He is not a party to the default. He has suffered, and he shall be reimbursed by the government. So this much you have to write for the word revenue sale. So side heading you put short notes. Okay. So section 73 gives the right to the mortgagee to secure his money from the governmental authorities in case of a revenue sale of that mortgaged property. Okay, so one word you have understood. Now another word, another business. What is the meaning of acquisition and compensation on acquisition? Can anyone tell me? What is the meaning of acquisition or compensation on acquisition? Come on, general knowledge.
So acquisition in general means acquiring someone's property, like we will acquire. So if the acquiring can be done in illegal way also and legal manner also. So in case if it is done without permission or because of illegal means, so the person whose properties are acquired, they will have a right for compensation for the same.
Oh, yes, yes, yes. Is she correct? Others? Is she right?
Yes, sir.
Can you add
Yes, sir.
anything to this? Can you add anything to this?
Sir, like government also has the right to acquire the properties of private persons for the benefit of public purposes. For the
Very good. Very good. Very good. Very good. So one day will come in our country. One ruler will come in our country and he will say, from today night, 11 o'clock or 12 o'clock, all your property will be ours. We are acquiring all your property. You are no more the owners of the properties. Who knows? That day may come to our country. Forget that one. Acquisition. Government is always considered to be useful, beneficial, serving the common people of the country. Government must be always protecting the people. Government is having the right to lawfully, I'm using the word, government is having the right to lawfully acquire the properties of private persons for a lawful purpose which is beneficial to the common public. See, very carefully you must understand this. Government is having the right to acquire the properties of private persons for a purpose beneficial to the common public. Now I'll give you one or two illustrations and you have to tell me, is it beneficial to the common public or not? First point. Consider the present problem which we are facing today. Consider the present problem. The government wants to immediately establish a temporary hospital on a large scale on a land of a private person. Immediately the government wants to acquire. So the government immediately gave a notice to that owner of that property saying, we are acquiring your property for the next 5 years. Now we are creating a temporary hospital. You know, the Chinese people have done that and we cannot do that. So, quarantining the people, the infected people, in the safer place and the government has acquired the land of a private person. Now the question is it a lawful purpose? Is it beneficial to the public or not?
Yes, sir, it is.
Yes, beneficial.
Okay. I'll proceed ahead. Now you have to compare. The government acquired the private person's land for favoring a particular industrialist so that he can construct his factory or industry. Now, out of these two, which acquisition is lawful, which acquisition is for the benefit of the common public?
So the first one.
The first one.
First one, why not the second?
So because it will only benefit a particular person, sir, for setting up his industry or factory over the area.
Some about 6-7 months back, one industrialist from India went to Australia. He wanted to start an industry there. And the people of Australia have simply raised their voice, saying, this industrialist is a fraud. He should not be given the land in Australia. And the opposition by the people was total. And that industrialist is looting our country, and the Australians kicked them out of their country. Okay? So now, consider the government is lawfully acquiring the property, and when the government lawfully acquires the property for a public purpose, such as hospital construction, such as road construction, such as residential layouts, etc., etc., etc. And the government, it is also having the duty to pay fair compensation. I'm using the word fair compensation to the owners of the land as early as possible. They should not say, I will give after 10 years or after 20 years. No, that is nonsense. They must give in 6 months or 8 months. They have to give as early as possible. When such an amount is given, we call it as compensation on acquisition. Now let us take one such illustration. Consider one Mr. A. He is the owner of an agricultural land. One Mr. A is the owner of an agricultural land. He has mortgaged the land to Mr. B for a good amount. For many years. For 20 years, let us presume. For 20 years. So Mr. A has mortgaged the land to Mr. B for 20 years. Consider for 20 lakhs of rupees. Mr. B started utilizing the property lawfully, peacefully, openly, but government gave a notice to the owner for the acquisition of the land for the construction of roads and residential layouts. So the owner, Mr. A, received that notice from the government. After giving notice, the government, in a matter of 4 or 5 months, they came, acquired the property and removed the mortgagee from the possession of the property. So the mortgagee was sent out of the property. The property is no more a security to the mortgage, and the mortgagee has lost the property. So there, this section says, mortgagee, he may get the money from the mortgager if the mortgager can pay, or if the government has acquired the property and is taking time for the payment of the compensation to the mortgager or to the owner of that land, then the mortgagee, he may wait or he may not wait. He can make a petition to the concerned governmental authority. He can make a petition. He must provide all the proofs of mortgage, and that authority, who is supposed to give the compensation, fair compensation, receives that petition, then the government is going to give a notice to the mortgager. They will fix the date and time for the conduct of inquiry. The mortgager and the mortgagee both will be present in before that authority, and the authority will conduct the inquiry, and the government, after satisfying the authorities, after satisfying the existence of the mortgage transaction, they can pay the money to the mortgagee. So, Section 73 gives the right to the mortgagee when the property has been lost due to the revenue sale, or when the property has been acquired by the government for a public purposes. The mortgagee can secure the amount of mortgage from the concerned authorities. So this is the right available to the mortgagee, Section 73. So in the exam, they may ask you the main question on this topic, or sometimes they will split you. The right to proceeds of revenue sale, that is one short notes, and another short notes, right to compensation on acquisition. They will divide it. Okay? So you have to write simply this much. Okay. So we will go to the next section. Section 74 is not at all there. Okay. Section 75 not at all there. It has been repealed. And then another important section, section 76. Liabilities of mortgagee in possession. That means the heading says the responsibilities or the duties of mortgagee who are enjoying the possession of the property. Remember, the mortgagees having the possession of the property and the mortgagees having no possession of the property. You have to remember. So this section 76 applies to those mortgagees who are having the possession of the property. Now, what are their responsibilities? What are their duties towards that property? First point, duty to manage the property as a man of ordinary, reasonable prudence. You know, we have the natural brain, the normal thinking. We all have a feeling, we all have a psychology. The psychology of caring, protecting, guarding the properties belonging to us. We know how to take care of our purse. We know how to take care of our vehicles. We know how to take care of anything which belongs to us. So, as the owner, we take care of the property. But a person who is not the owner of property, he may not take the same care as he will take to his own property. So this point says, the mortgagee who is having the possession of the property is having the duty to manage the property as an ordinary man, as a reasonable man with an ordinary mind. He has to take. Now, what kind of thing that he has to take? You know, if it is your own house, either with servants or without servants, every day you will keep quiet. Every day you will take care of that property. You will keep neat and tidy the entire property. You are going to dust the property or remove the unwanted things from the property. You will dust, you will clean, you will swap, you will mop, so many things you do. But the mortgagee who is having possession must behave as if he is the owner of that property in protecting, guarding, maintaining, cleaning, repairing that property. He has to take care. Okay, write about 4-5 sentences. Next point. Duty to collect rents and profits.
So these are under section 76 itself
Yes, ma.
as a liability.
Yes, ma. Liabilities of mortgagee in possession under section 76. Second one, a duty to collect rents and profits. I have told you there are 6 kinds of mortgages. One of the mortgage was called usufructuary mortgage. Usufructuary means the benefits arising from that property. In the modern world, generally the benefit is the rent in the form of money. The monthly rent or annual rent. Monthly rent or annual rent. Or in case of agricultural land, the sharing of crops, sharing of food grains that has been grown in that land. It is called the profit. So, any such property which is giving rise to the rents or profits or any other form of benefit, and the owner of this property has given the possession of the property, or the owner has given the right to collect the rents and profits to the mortgagee, then that mortgagee has the duty to collect all the rents, all the profits periodically without any defaults. The mortgagee must collect that amount. The mortgagee must not be lazy, must not be careless in the matter. Now let us consider one small illustration. Nowadays we are having malls. So many big malls for the hi-fi life, for the modernity of finding happiness. And now it has become source of infection also. Consider one such mall with so many shops, restaurants, theaters, etc., etc., etc. Consider that mall belongs to one particular Mr. A. Mr. A is the owner of one such mall. Consider there are about 50 establishments inside that mall. Just for our easy analysis. Consider there are about 50 establishments inside that mall. Mr. A is the owner. Mr. A mortgaged the mall to State Bank of India for some crores. State Bank of India has given that loan, and that right was delivered to the bank saying, Mr. Bank authorities, you please visit the mall. Every month you collect all the rents from each and every establishment until the complete satisfaction of the loan amount. I think the mortgagees will definitely, the bank as a mortgagee will definitely do this work, do this duty. Because they are getting the money, they are getting the profit, so they may not be lazy and they will be very active. So the bank authorities, once in a month or twice in a month, they have to go to that place and to collect the rents periodically. So this is the second point. Now the third point. Duty to pay governmental taxes. See, the taxes shall be paid by the absolute owners of property. Taxes shall be paid by the absolute owners of immovable property. And generally this duty should not be given to the others who are not the owners. But in some mortgages, the mortgager is going to give the possession of the property to the mortgagee, and a duty is imposed on the mortgagee so that he has to clear the taxes. The mortgagee may not be the owner of the property, but the mortgagee has paid the loan for which he is having the possession of the property as a valuable security. The mortgagee has to protect himself, has to protect the lawful security. So the mortgagee is going to pay the governmental taxes. He should not be a defaulter. Right? Next. The next duty, not to do an act which may destroy the property. Mortgagees is having the duty to guard, protect, maintain the property until the complete period of that mortgage. The mortgagee may take care of that property, but some mortgagees who are having a sadistic thinking, a mind of destruction, such persons may try to destroy that property. For example, consider an agricultural land, a kind of a farm, and there are valuable trees in that farm. There are valuable trees in that farm. There are sandalwood trees in that farm. And the owner has mortgaged the farm to a bank. The owner has mortgaged the farm to a bank. The bank manager took the possession of the property, and after some days, the bank manager came to know about the presence of sandalwood. You know, chandan, one of the costliest wood, one of the useful wood to the humanity. The bank manager, he is having a dirty mind running, and he decided to sell off all the sandalwood in the farm for a very good price. Naturally, the bank manager, that is the mortgagee, he called upon the people and severed the sandalwood and sold it to them. Now he has made enough money, sufficient money, but the act of selling of the sandalwood from the farm is an act of destruction. Such an act is going to destroy the value of that property. So it is a very, very bad act on the part of the mortgagee. So the law says, hey, Mr. Mortgagee, protect this property, and you should not do any act which is going to destroy the value of the property. Do not do any such things. But law is law, law is in the book. Okay, now let us go to this one. Next point. Duty to receive and apply the insurance money. I think we have the insurance business, insurance laws. Generally in our country, there is a life insurance. There are many life insurance. And as the modernity is growing, there are insurances for everything. There are insurances for everything. What is insurance? It is a guarantee to pay certain amount of money specified amount of money in case of loss, destruction, death, injury, etc., 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 etc. There are people nowadays who are taking the insurance policy on their houses, on their buildings. Any such insurance policy has been taken on a house or a building, and the owner of that property has insured and he has mortgaged that property to the mortgagee. He has given the possession to the mortgagee. And now, the mortgager, since he is raising the money, he is receiving the loan, and he may transfer his duty to pay the installments or any such things to the insurance company. So, he may just pass the duty to the mortgagee, and the mortgagee, he has to take care of that property. He has to pay the money, the periodical installments to the insurance company. He should not be a default there. By act of misfortune or something, if an accident takes place to that property, if there is a fire or some destruction takes place to the property, then the law says, you the mortgagee, make application to the insurance company and try to get the required amount of money or the insurance money and utilize that insurance money in rebuilding, restructuring the same property to its originality. Generally, this will not happen. Generally, this is not in, the owners will take care of their property. They don't give their this right to that mortgagees. But here is only there in case he may insure or he may pay the installments, and in case of accidents he can go, move that authority and to get back the money and to use the money to rebuild that property to its originality. And then the last thing is duty to keep proper accounts of income and expenses. We bring the names of God and goddesses when income comes. So, false accounts and duplicate accounts or bogus accounts or original accounts. But here the duty is imposed on the mortgagee. You have the property in your possession. You are spending money on the property. So, Mr. Mortgagee, maintain proper accounts, lawful accounts, accounts of all the income received and all the lawful expenses that you have made. So keep all the accounts properly so that it may be inspected by the mortgager or it may be inspected by the courts or by any authorities. And the last section here, Section 77, receipts in lieu of interest. See, when the mortgagee is having the possession of that property, consider there are so much of income is arising. Consider a property and there are some 50 shops and establishments, and every month they are paying the rent to the mortgagee, whatever lawful amount is received towards that property, the mortgagee is having the right to give a receipt for the same. For example, if one shop owner gives the rent and immediately the mortgagee has to give a receipt for the same. Okay, so this right is available to the mortgagee. So this much is enough. Section 67 to 77, the rights and liabilities of the mortgagee. Okay, yeah, enough for today. I will send these notes to you tomorrow. Okay, yeah, so
Yes.
yes, ma.